Okay, we are calling to order. We're calling to order the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting of September 24th, 2019. So first, could you please call the roll, do the roll call?
Call to order, roll call, and agenda changes. Chris Hyland?
Present.
Chris Hyland present. Fiona Hinsey?
Present.
Fiona Hinsey present. Chair LaHood?
Present.
Chair LaHood present. We have a quorum.
Okay, next we're going to review the minutes from the last meeting.
Item number 2, approval of the August 27, 2019 Compliance and Amendments Committee meeting minutes. Any changes?
No.
Any changes?
Nope. Madam Chair, I'll go ahead and move the that we approve the minutes of our last meeting.
Just for the record, I think Chair LaHood was the only one present at that meeting, so maybe you should weigh in to see if you see
I
anything.
think, was I not there?
Yeah,
I
no,
think I was there.
Member Hinsey was there as well.
I stand corrected.
Yeah.
I was the only one not present, so I'll shut up.
Yes.
Okay, I will second, and I suppose we can take these by acclamation?
Yes,
Sure.
Member Hinsey, you made the motion?
Yes.
Okay, LaHood, Chair LaHood second the motion. Let's take the roll. Member Hinsey?
Yes.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Member Hyland?
Pass.
Pass? Okay. Minutes have been ordered.
Okay, next item, please.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Do we have any members of the public who would like to make a public comment?
Good evening, members of the Compliance Amendment.
Hang on one second, we're going to start the clock. You have 3 minutes.
Good evening, members of the Compliance and Amendments Committee. Ray Hartz, Director, San Francisco Open Government. And as I've said to you and say to every city board or commission meeting that I attend, my primary purpose is to ensure that the Sunshine Ordinance is followed in accordance with the rule of law. And I recently, or in August, I attended a meeting of the zoo. I can't remember exactly what their name, and I informed them. I clearly said to them that.
So, point of order, that's actually on our agenda.
It's on the agenda.
Well, I'm not talking about this item on the agenda. I'm talking about my attendance at that meeting.
Okay.
At the meeting, I told them that number one, they were required to record the meeting. And in September, to the best of my knowledge, they failed to do so, even though they were told. So there will be a complaint coming about that. And I submitted a 150-word summary to them, which clearly stated the Sunshine Ordinance findings that they should be included in the minutes. And I filed a complaint today, gave it to Ms. Ledger, against them for failing to put that summary in the minutes. They put in, I think, 2 sentences from it, and that was it. So basically, I go in and I give people fair warning. I say, I'm here for these 2 reasons. One, to ensure that the Sunshine Ordinance is followed as resolved as concerns public meetings. And number 2, that it is followed as concerns the getting of public records by members of the public. And for whatever reason, primarily, in my opinion, because they don't want people to see the things that they're being asked for, they just decide they're not going to follow the law. And I think at some point it ought to just become willful, because it's very honestly, this has been the law for many, many years. They know they're required to comply with it, and they simply get it in their head not to comply. And it doesn't matter what somebody says to them, they will simply refuse to do so. At some point, I think we ought to move past the idea that they don't know what's required by the law and just say, it's your responsibility. You all went through the training for the Sunshine Ordinance, and you're required to recertify every year that you know what the requirements of the law are, and yet you will refuse to follow them. And even after years of being told to do so, will just refuse. And it's, to me, it's just pig-headedness is what it is.
Thank you, Mr. Hartz. Do we have any other members of the public who'd like to speak about items not on the agenda? Seeing no further public comment, next
I
item.
do want to speak about an agenda change, which I should have done when item 2 was discussed, and that is that.
Let's close public comment first, if you want to.
I'm probably-
Okay, so we're closing public comment.
Set? Okay. This is an agenda change, and I apologize for not mentioning this earlier. Peter Dolan let me know. I got his message yesterday that he would be unavailable to attend today's hearing. And his item is item number 7.
And was the other party notified?
Yes, I notified the other party that they didn't have to appear.
Okay, so we'll just postpone this until our next meeting?
Yes.
Okay, thank you. So then I think we're ready for the next item.
Item 4?
Yep.
Item number 4, file number 19048, hearing on the status of the order of determination, complaint filed by Justin Barker against the San Francisco Zoo for violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Is Mr. Barker here? And is someone representing the respondent here? Is there anyone from the zoo here? Okay, shall we proceed anyway?
Yeah.
Okay, Mr. Barker?
Before he approaches through the chair, this is based on an already existing order determination, correct?
Correct.
Is that in our package?
It should be.
I don't see it checked as far as the index at the top. It doesn't refer a page to it. Is it within the rest of the preamble?
I thought I put it in there. If I didn't, I could go
Was it-
downstairs and.
Well, it'd be useful to know what we're trying to enforce. Give me a second. Let me take a look, see if it's buried in here. I just saw that it's not indexed. Did the other members, do you see it?
This was a recent thing, so I assumed that it was all in the packet.
Yeah, and I didn't see it either. So.
Give us 1 second. I see the initial complaint. I see the Wolf Price's memo.
I think it's because the order of determination was signed by Chair Wolf after the packet had been uploaded.
Okay. Would that be in our minutes?
It would have been in the minutes from the full task force,
And is
which
that-
we don't have yet because that was at the last.
Okay. All right. Just want to check on that.
I do want to say that I heard from Vidas Lung, who is from the zoo. He submitted at 2:30 this afternoon an email with an attached letter, which I have here. So that did not get into the packet. It was just arrived today.
I think we have to decide whether, well, I guess this is just an enforcement, so I guess we can.
Since this is an enforcement, I would say that
All right.
that we could accept that. Should we take that now, or should we hear from Mr. Barker first?
Determinations in that packet that was shared
is.
with me.
What?
It is?
What
Okay.
Do you know what page it's on?
Sorry, the one that she's holding. It wasn't that.
No,
This
this
was not
is
included
this is
in the
something
packet.
new from the respondent, and that's raises yet another question.
I got it today at 2:30 in the afternoon, so it didn't make it into the packet.
I might recommend that we
Yeah.
push this back an item if Mr. Barker's okay with that. Give him a chance to read this,
To
give
read
us a
it,
chance
yeah.
to digest it, because
Okay.
it's not
Yeah.
exactly short.
And the zoo's not here anyway, so.
Mr. Barker, do you mind if we push you back one item so you can have a chance to look at their response?
I have it actually.
He does have it.
I do
Oh.
have it, and that response included the zoo attached the order of determination. So I don't know if
Perfect.
that's helpful.
Okay.
Perfect. Let's move
Great.
forward based on that.
Okay, so we are accepting this into the record.
Okay.
Okay. And are we ready with the timer for Mr. Barker?
Hang on a second. Ready?
Good evening. My name is Justin Barker. About a year ago, I was on a regular shopping trip to Costco, and I noticed a plaque on the wall that read our code of ethics. And one of the first bullet points was obey the law. And at the time, I thought that this was kind of a weird thing to include in your code of ethics, because honestly, at the time, I thought, what legitimate business doesn't follow laws? And about the same time, I started attempting to better understand the state of the San Francisco Zoo through public records requests. And I quickly realized that indeed, that seemingly legitimate businesses break the law and that obeying the law is an honorable commitment for a business to make. Last month, this task force found that the San Francisco Zoo has violated Administrative Code Section 67.21, 67.27, the California Government Code 6253, and the California Business and Professions Code 4857. Despite your anonymous vote, Jason Waters told Chair Bruce Wolfe that the entire task force, the zoo intended to continue breaking the law. During the August Joint Zoo Commission, a meeting that is between the San Francisco Park and Recs and the Zoological Society, Vitus Liang, who was president at the unanimous vote, told President Mark Buell that the Zoological Society contends that they are protected by attorney-client communication privileges and our personal and patient confidentiality and will not hand over documents. A few days after the Sunshine Ordinance Task Force was determined, or sent the determination, I emailed an immediate disclosure request that expanded my requests and CC'd the task force. After no response, Cheryl asked the zoo for an update in which Vitus Luang replied stating, my requests were far-reaching, overly burdensome, and intrusive on the Zoological Society and is not subject. The Zoological Society is not subject to broad sweeps of Public Records Act or the Sunshine Ordinance. It's become really clear that the San Francisco Zoo has no regard for the law, its lease agreement with the city, or the jurisdiction of the task force. Tanya Peterson is the zoo director and the board president of the Zoological Society. She's a lawyer by trade and the only person who I have made records requests to, and the only person who could be held accountable for the actions of the zoo and the Zoological Society. Today, I'm requesting that you forward this matter to the Ethics Commission and solely list Tanya Peterson as the department head who has willfully violated the Administration Code, Section 67.21, 67.27, the California Government's Code 6253, and that profession's Code 4857. Transparency and public records requests are so important for places like the San Francisco Zoo, and we really deserve a zoo whose management is transparent with its citizens and follows through on the lease agreement that they have with the city, and most importantly, with city, state, and federal laws. I'm really grateful that you've taken the time to hear this and take action on my complaint. Thank you.
Thank you. And just to make sure, do we have anyone here representing the zoo? Seeing no one, we do have this letter, and
just first thoughts. I did read Mark Price Wolf's memo on this, and I think that was part of the reason that you guys came up with this order of termination last month. That basically they've signed on and they have to agree to certain things, and it was a pretty unanimous decision. They were asked to provide legal background as to why the records were withheld. I don't see that here. I just see it, I'm not sure what these important clarifications, they're just saying they disagree. That's how I'm reading this. Looks pretty black and white to me.
it seems that they just disagree with our decision, and
Right.
so they're saying we disagree and we don't want to comply.
Right. Well, I can't think of a better case to go to the Ethics Commission than this. The other possibility is, to go the legal route, but this is probably something we want to bounce back to the full committee with our recommendation and let them take a vote on sending it to that next stage would be my...
That seems appropriate. Member Hinsey, do you have additional thoughts?
Yeah. That seems appropriate.
Do we need to hear a response from the complainant or petitioner, excuse me,
Both.
respondent?
We
No.
we typically give them a chance to respond. But
I did not hear word that they wouldn't show up. Maybe
I see.
this letter is in a lieu of appearance. I don't
That was
know,
my
but-
impression when you said that they had submitted the letter.
right,
Yeah.
yeah.
Yeah, please see attached column or email if questions arise. That seems pretty clear. Not going to be there, submitted 2 hours before.
Yeah.
I don't think they have anything further to say. So.
All right. So they're not here. I meant, do we hear again from the petitioner, or do we just?
No, I think
Take a
we're-
motion.
I think
Have a mo-
I think
yeah.
we can just vote to send this back to the full task force with a recommendation, and let the respondent also know that's what's happening.
Right.
Is that your motion?
That is a motion.
Do I have a second?
Did you want to say what that recommendation was?
I'll let the full task force determine whether it goes to ethics or,
Okay.
we've been sending some to the district attorney as well. So,
So your motion is to send this back to the full task force.
for recommendation to a higher body.
Okay.
Okay,
How's that?
I'll second that.
Okay.
We can take public comment
How
on that.
about
Should we? We'll take public comment on the motion.
Members of the Compliance Amendments Committee, Ray Hartz, Director, San Francisco Open Government, and I fully support what you've decided to do.
Mr. Hartz, 1 second. We need a timer.
Timer.
Thank you. Thank you.
Again, Ray Hartz, Director, San Francisco Open Government, and I fully support the action you have chosen to make a motion upon. I think from my own experience with this group, they have no intention of following the law. For some reason, they do not want to give Mr. Barker the documents that he's requested, and they do not want to follow the law in giving him the legal basis of the withholding. And the law clearly states that there are certain things that can be withheld and what those things are and what the legal basis is, and they could very easily look at the law and make that determination. Instead, what they've chosen is to simply ignore your jurisdiction completely, I think, by not showing up here, and instead sending this letter, which is really kind of a we disagree, and basically they're thumbing their nose at the task force, saying we don't agree with your decision and we're not going to follow it. Now, again, as I mentioned earlier during public comment, I also have one complaint that I've already filed, and I'm going to be filing another because they just don't seem to be willing to even acknowledge that the Sunshine Task Ordinance exists, and they certainly don't seem willing to follow the law, which is not only the ordinance itself, but the Brown Act and the California Public Records Act are also being violated. I would even suggest that maybe the task force should consider a willful violation, because that's, to me, what this is.
Thank you. Is there any further public comment? Seeing no further public comment, shall we take a vote on this motion?
Sure.
Ready? Member Highland?
Aye.
Member Highland, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to send this matter back to the task force is passed.
Thank you. Let's consider the next item, please.
Item number 5, file number 16117, hearing on the status of the order of determination, complaint filed by Ray Hartz against the city librarian Luis Herrera and the public library for violating Administrative Code Section 6729-6 by failing to disclose the amount and source of all outside funds or services worth more than $100 in aggregate accepted by the public library for the purpose of carrying out or assisting any city function on their website.
Okay, I know Mr. Hartz is here. Do we have a representative from the library? Okay. So we'll hear from Mr. Hartz first. And are we ready with the clock? Yes. Please proceed.
Members of the Compliance Amendments Committee, Ray Hartz, Director, San Francisco Open Government. All the documents that I think you need to see are in the file. The one that I would like to particularly point out is one I submitted via email on pages 262 and 260. 256 and 257 of your packet. And I've pretty well laid out my case there, and it's the fact that for more than a decade now, the library has done everything they could to bend over backwards to protect the Friends of the San Francisco Public Library from having to disclose anything about their operation. The only reason that the library is in compliance now is because I filed numerous complaints against them. The task force has found them in violation, and ultimately they have started now to provide the documents they do have on the library website, and the Friends themselves have also put documents on their website. But the library continues adamantly to oppose making them responsible for following the Sunshine Ordinance. And they have repeatedly argued that the section of the ordinance which says they have to comply says specifically shall agree to comply with the ordinance. It doesn't say this section of the ordinance, says the ordinance. And as I've stated in here, my understanding of the Sunshine Ordinance is that it is to be read in the way that will give maximum transparency and disclosure to the public, and therefore reading that as limited to the section specific, the specific section is limiting, and it's what the library wants. My preference is that it follow what the wording actually says, that they shall abide by the ordinance, and that means the full ordinance. And the sort of humbug presentation by the city attorney's office is basically giving all these hypotheticals and what a judge would probably do or not do. And really what we need to do is let the law run its course. And if it gets to court, then let a real judge actually make these decisions, not the city attorney in support of the library trying to give them something to hide behind, basically. This group, the Friends, raises millions of dollars every year. The best average I can give you is they raise about $4 to $4.5 million a year, and they actually give to the library, if they meet completely the accept and expend grant approved by the Board of Supervisors, $400,000. $400,000 out of $4 million is 10%. And the documents that we're discussing in this case show very clearly that in all the years the Friends have been operating like this, they raise millions each year, and the library gets at a max I think one year they got $420,000. So I think this is a public fraud. It is the library telling the members of the public, if you want to support the library, contribute to this group, and yet they're denying any responsibility, any fiduciary responsibility, any responsibility at all. In fact, the Library Commission has refused to even discuss the matter at open session at all. They refused to put it on the agenda. The one thing we have managed to achieve is the fact the Friends no longer come to the Library Commission meetings and lie to the public. They would come and they would tell the public that they were given this huge gift and all the wonderful things, and the Library Commission members and the library would, oh, yay, it's a great relationship. In fact, on the hearing before the full task force on this matter, the new city librarian, Michael Lambert, said, oh, well, we couldn't have done the library branch library improvement program without the Friends. Well, the bottom line is the Friends also use that to raise funds, and it's also questionable as to how much of those funds actually made it to the library for the support of the blip. I've also tried to get information about the funding for the new center they built for called the Mix in the main branch, and that hasn't come up. The Friends makes all these commitments. They then raise money based on those commitments, and then when it comes to actually meeting the commitments, they present unsupported claims that they gave X number of dollars. You know, very frankly, if the public library, which is a city department, uses the city department's website, the public library's website, to steer people to this group, I think that is taken as an endorsement of its not only its credibility, but also its financial and fiduciary responsibilities. And I don't even think there's a legal basis for them to allow this group to raise money. The only thing they have is an agreement between Michael Lambert and the Friends. It was not approved by the Board of Supervisors. It was not approved by the mayor's office. It was not approved, as I can tell, by anybody. And as far as I can tell, it's a personal agreement between Michael Lambert and this group. You can raise money in the name of a city department. And he's a city department head, so I guess, he could say that falls in his bailiwick, so to speak. But I have real questions as to whether any city department head can give a group of unnamed and unmonitored people to raise money in the name of that department and expend all that money without reporting to anybody. And especially, I hate the idea that the library is bending over backwards, and I know why they're doing it. They're doing it to cover their own backside. And I noticed the chief financial officer for the library is here. You might want to ask her when she gets up whether or not prior to my efforts there were any documents available regarding this group, or whether it was all done in the dark.
Thank you. We'd like to hear from the library, and actually I have a question for my fellow task force members. One of the things that we're supposed to be doing today is reviewing the, I just lost the item, reviewing the MOD, which, just to clarify, I believe is on page 279, just to make sure that we're referring to that. Yes, please come up. And are we ready with the clock? Mm-hmm. Thank you.
Thank you. Good afternoon. My name is Maureen Singleton. I'm the Chief Operating Officer with the library. And I just wanted to provide some background information. We do have an MOU with the San Francisco Public Library Friends of. And in that, based on city attorney opinion, we have as an attachment in that MOU that the applicable section of the Sunshine Ordinance is 67.29-6. And again, that was based on city attorney opinion that that was the applicable section and not the entirety of the Sunshine Ordinance. On our website, we do provide access to the information on the gifts that are received directly at the library, as well as a link to the Friends where they provide information on the donors that provide donations in excess of $100. And all of that information is current through the end of August, and then it'll be updated on a monthly basis on the Friends side. So I'm available if you have any additional questions.
And your name is Maureen Singleton?
Yes, Maureen Singleton.
Thank you.
So, do we have questions?
I just want to read the order determination again here, and perhaps ask Mr. Hartz for his position on that. We found the violation of that section. To refer the matter to CAC to review the MOU between the public library and the Friends of and to ensure that the administrative code, Sunshine Ordinance, section 67.96 is addressed. Mr. Hartz, if you could approach. So I just reread on page 248 of our package the OD as we came out with it. And this is going back
Correct.
to like March of last year. And I think you said that you're reading that, but then you're, and from that, it seems like they've satisfied that piece. In other words, they're now documenting those donations on their website, and it sounds like the Friends is also going to be updating that. Are we on the same page with all that?
No.
Okay.
And the reason I say that is if you read the actual section of the ordinance of which they were found in violation, it says that any group that accepts money has to agree to abide by the Sunshine Ordinance. It doesn't say this section of the Sunshine Ordinance, it says the Sunshine Ordinance. Now, if the task force decides that that is restricted to that particular subsection, then yes, they have complied with the order of determination. But if you read it as it is written, the plain English language says they shall abide by the Sunshine Ordinance, then no, they have not, because they are still continuing to refuse to acknowledge the responsibility of this group to abide by the full ordinance. And that's what it says. It says they shall abide by the Sunshine Ordinance. And they want to take the most restrictive reading possible and say, well, they're only required to follow that one subsection of the ordinance. And my argument is no. It says in plain English, they shall agree to abide by the Sunshine Ordinance. And my argument, as I again put in those 2 pages that I mentioned earlier, is the fact that any group who someone of the public can get up and say it's a scam, it's a fraud, would normally show up and prove that the person was wrong. And they have not. They haven't even denied that what I've said is correct. In fact, what they have done is they have quit showing up at all at the Library Commission meetings, except when they sneak in during public comment and put in a plug for one of their fundraisers.
So I've just reread 6929.6, and I'm leaning to agree with Mr. Hartz. I mean, our order of determination found them in violation of that section. That section, and I'll paraphrase it here. No official or employee or agent of the city shall accept, allow to be collected, or direct, or influence the spending of any money or any goods or services worth more than $100 in aggregate for the purpose of carrying out or assisting any city function, unless the amount and source of all such funds is disclosed as a public record and made available on the website for the department to which the funds are directed. When such funds are provided or managed by an entity and not an individual, that entity must agree in writing to abide by this ordinance.
This is interesting because if we look at the initial complaint, it was specifically about 6729.6 and failing to disclose the amount and source of outside funds or services worth more than $100 in aggregate. They are responding to that, and they are publishing that information. So in terms of responding to the initial complaint, they seem to be doing that, except that I see what you're saying, but I don't know how we get around the fact that they are responding to the initial complaint by providing the information that was initially not provided.
Right, but then going forward on the website, all this should be provided de facto. That's the point that I'm now seeing that I think Mr. Hartz is making. And can we compel them to do that based on what we have here, or is this another item that needs to be, put through the mill, so to speak?
So what you're, help me, is what you're requesting then a letter that acknowledges not just this section of the ordinance, but a letter acknowledging compliance with the full
Or we
ordinance?
can just say, it's clear to us that based on our finding of violation, our order determination, that you're compelled to follow this ordinance going forward. And if for some reason we don't see evidence of that, then we can take action on that, put this back to the full task force, and go that route.
Meaning the Sunshine Ordinance, not just this
Yes.
one piece of it.
Yes. Yeah. Perhaps someone from the other side would like to comment to that?
Yeah, I'm Marie Sapella. I'm the executive director of Friends of the San Francisco Public Library, and I faithfully get to all of the meetings that I need to. And it is just sort of a long-running complaint against us that is longer than almost our history. But we have, and we have always disclosed our donors. So right now, as you can see, for this particular, as you are saying, for this particular complaint that was brought, we are in compliance. The donors are posted at the 10th of the month and can be viewed on Friends SF pl.org, our supporters, and that is available at any time, and it's linked, as Maureen Singleton says. All the other issues of who we are and what we've done. We've been in business since 1961. We have an audit every year. We have a 990 every year. We have an annual report every year, and everything is absolutely out in the open. Yes, we did give $500,000 for the equipment in the mix. Yes, we did fund all of furniture and fixtures in. It's all documented, and it's just simply a repetition of Mr. Hart's over and over and over and over again to not say what is true. Our organization has programs. It's direct philanthropic support to the library. Its book program earned revenue to support literacy and the library's mission. It raises money as well. We have a volunteer program. We advocate for the Library Preservation Fund. All of this is described at the highest level of transparency and celebration, by the way, on our website, in our annual reports, in our newsletter, in our social media feed. We are no different than any other nonprofit organization. You can look up our documents. There is nothing to hide, and we have never hidden anything, and we are bound by the laws of the IRS and every other entity in California that regulates nonprofits. There's full disclosure audits, 990. Look us up on Charity Navigator, and we operate within our mission, which is support the library and its mission. We do not believe we are subjected to the entirety of the Brown Act. We have complied exactly the way that we have been told to by this commission, and I hope that level heads will prevail here. Thank you.
Maureen Singleton again with the library. I just wanted to reiterate that we were acting upon city attorney advice that the section that we're talking about was just that subsection of the Sunshine Ordinance and not the entirety of it. So with respect to advice from the city attorney, we believe that we are in compliance. We do provide the information on the donors on an ongoing and regular basis. So that information shows and is accessible, and therefore we're in compliance with that section.
Excuse me, you're from the library?
Yes.
And your colleague is from the Friends?
Yes.
Okay.
Marie was from the Friends.
Yeah.
Now I understand. Thank you.
Yeah.
Members, what are we thinking?
I'd actually like to bounce this back to our city attorney to get some input, because to hear that that you feel that they've been told that they are responsible for a certain section of the code, but not the rest. That's the first time I've heard that in my 8 years sitting up here, that you can get advice as to which ones you follow, which ones you don't.
And they do seem to be, they are complying with that section.
They are. So as far as the actual, order determination, I'm fairly comfortable that they've complied with it. But this might be something that we can open up and kind of investigate ourselves and get Mark Price Wolf to opine from the other side of the line as to that, and also their comment about that we don't feel that we're subject to the Brown Act was of note to me as well. I'd kind of like to look at those two things a bit more closely. I know that it's an interesting entity, the way it's set up.
Well, and I want to say, did we not get, and Cheryl, you might be in a better position to answer this, but did we not get some similar opinion on what Chris is referencing from our city attorney? Because I want to say this has been an issue, and we were getting an MOU, and
it feels very familiar.
It feels, yeah.
I mean, this took place, some time ago.
Yeah,
this initial case, so we have to go back. In fact, I was the one that made the motion for the OD back in March of 2017, I believe. So, but I'm looking back. I think it wasn't Mark Price Wolf. It would have been Nick Cola. Yep. Just a 2-page. There wasn't much on this.
This feels similar to the MOU.
Yeah, so I think the reason why this feels so similar is this issue has come up not only with the library, but the zoo and the fine art museums. And so the task force is grappling with the same issue across lots of organizations. It seems like in terms of the 67.29-6, they are complying. But is there a way to close out an item yet maintain, for the task force to further investigate this broader issue, which goes across many organizations, and we should be consistent?
I mean, I think we could open up a file regarding that issue and maybe refer it to EOT, but we would need an ongoing open case, I believe, to
No,
sort of,
I don't think so. We can open a file and we
we
can.
we can't open a file. All right.
Yeah, we can do
That
that.
works.
Just before we move forward, I just wanted to ask Mr. Hartz a quick question. So you can see what we're kind of grappling with here. At the risk of launching you in a 10-minute rebuttal, outside of 6729.6, what else do you think these two organizations should be doing if they were subject? That's why I prefaced it with that, to the full Sunshine Ordinance.
Very honestly, I think that any honest person would be willing to comply with any part of the ordinance which if you read it, was applicable. They seem determined to restrict it to this one specific subsection of a section. Mm-hmm. And very honestly, they're constantly saying the city attorney's advice, and all that is hearsay. We don't know what the city attorney advised them and how they're choosing to read what they were given or told. And Ms. Cipiella is, making comments about my honesty. And very honestly, the only reason they're complying as far as they are right now is because of my efforts. Before I did anything, they didn't tell the public anything about what they raised or where it went or who donated. So I don't think it's over. I think there should be a discussion before the full task force about whether their reading of the ordinance, which is only that specific subsection, are they required to comply with? Or, as you said, with these other organizations, shouldn't they be complying with the entire ordinance? In other words, what have they got to hide?
Before you leave, Mr. Hartz, so as far as the specifics of this particular item, disclosing donations over $100, it looks like they're in compliance on both sides, from what I see.
But again, I'm saying it depends on how you read that subsection of the ordinance. If you read it as it's written, no, they're not in compliance because there are other sections of the ordinance. I can't name one offhand, but there are other sections which I feel they should be complying with.
Such as?
And they're arguing, if I make a public records request of the Friends, should they comply with the public records request?
Oh, I see what you're saying. Okay. So this,
their attitude has always been, no, we don't, and the libraries has always been, no, they don't have to.
yeah, this almost goes back to the silos analogy that we had with the other case with fine arts and tell the name the museum.
Mr. Smith.
Mr. Smith, yeah, that was a very live discussion. And is that still going through our system?
Yes, it is.
It is, right? So I think my instinct is to close this as it stands, open up our own file, tag it to that, because that's kind of an ongoing...
And it does seem like we need to group, and in some way group those organizations and have one overarching decision. Otherwise, it's going to be deja vu.
Right. I that's kind of where I'm leaning on this. But and to that, I'd also like to throw this back to Mark Price Wolf, and based on so let me make a motion to say that this particular OD has been satisfied in my estimation, and then the second piece is to open up a. Or maybe we should do that first separately. Okay, so I'll make a motion that this has been satisfied. This is really just we're looking into it. But if you'd like to say something, you're welcome to, and we'll let them also say something. But that's
so. Actually, shouldn't they go first?
Yeah.
Yeah.
Okay, so I'll let Chair LaHood do that then.
We'll hear from the respondent.
A second.
Thank you again, Maureen Singleton with the San Francisco Public Library. Just wanted to reiterate that we believe that we are in compliance because we are providing access to the information for donations in excess of $100 according to the subsection of the Sunshine Ordinance. You'll see in your packet, I believe it starts on page 272, the city attorney opinion that describes how they believe that this and only this section is applicable to our situation. So again, we feel that we are in compliance and have met the requirements to report out on this information according to that subsection of the Sunshine Ordinance. Thank you.
Thank you. Mr. Hartz?
And yes, if you take the most restrictive reading of that section of the ordinance, they are in compliance. But if you read it as it is written in the plain English language, which I think as librarians they might have some respect for, it says they shall comply with the ordinance. And again, my question to Ms. Cipiella is, why is she so determined not to be compliant with the Sunshine Ordinance? What is in the Sunshine Ordinance that they're so afraid of? I know one thing is one I mentioned already is that I make public records requests of them, and they want to be able to say we're not required to obey the Sunshine Ordinance, and we're not required to give you any documentation. And I know you can't get it from the library because the library doesn't have it. They have made an attempt over the last decade and more to not have any information. As Thomas Aquinas says, willful ignorance of what one ought to know is a mortal sin. And the library has chosen to be willfully ignorant for years about the amount of money the Friends raise and how they dispose of that money. And in most cases where you have a charity where 90% of the money does not go to the subject of the charity, that's considered to be a fraud. Because you're telling people this money is going to support the library, and they get up here and make a bunch of vague claims about, oh, we do this and we do that. But when you ask for some hard numbers, they stick their head in the sand and go, oh, we don't have to comply with the ordinance. Again, as far as complying with the ordinance, if you read the most restrictive reading of it possible, yes. But if you read it as it is written, and this is similar to my earlier case against the library regarding 150-word summaries that says they should be placed in the minutes. And the library was found in violation numerous times for failing to put them in the minutes. And then all of a sudden in 2017, even though they had specifically at the library commission meetings voted not to put them in the minutes, they started putting them in the minutes, which I think is an admission that they knew they were wrong all along. But they don't want to acknowledge it. And I think the same thing goes here. They are hiding from the public. And they can make all the false claims they want and all the generalizations about what they do from the library, but I'm talking about hard numbers. I'm talking about millions of dollars raised every year by the group, and the City Board of Supervisors authorizes them, the library, to accept a gift of $400,000 a year. So $400,000 out of $4 million or $5 million or in some cases $8 million, that's a scam. That's a fraud. The facts support it. The facts are there. No.
Point of order.
Your
It's not a
I
discussion.
think, yes.
Please stop
Ms.
interrupting.
Singleton, thank you. Mr. Hartz, thank you. Okay. So
I'll make a motion that this order of termination has been satisfied by the respondent.
Second.
let's vote, please.
Public comment on that.
Oh, public comment on the motion by individuals not involved. Seeing no public comment, let's call roll.
Member Highland?
Aye.
Member Highland, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion passes.
Thank you. And let's take up you, Member Highland, you had another recommendation.
Sure. We could open a file, and in the file we could start off as simple as a letter to our DCA, and I'd like him to take a look at the DCA's response on page 273 of our packet, with particular regard 273, which was the July 7th, 2017.
Actually, I think it begins on 272.
Yes, it does. Sorry. It's from Bradley Rusi, DCA, to Luis Herrera. And I'd like to get our DCA's take on that letter, specifically page 273, under the inset paragraph. The Sunshine Ordinance does not contain any other provision regarding whether or how it would apply to a third-party entity that provides funding to the city. I'd like them to look at that in conjunction with the ongoing Smith case that is in our system right now.
And I'd like to add also the ongoing Barker case. I mean, we keep running into this with public entities that have associated nonprofits.
Right.
And I think we keep running into the same question, and I think if we get some clarity across the board, it will help everyone.
Sounds good. And maybe we can just, start with that request to our DCA. And based on that response, we can then have that come back to this committee and then kind of get all the apples and oranges lined up and perhaps present it back to the full task force as a more packaged discussion agenda item.
So we are closing this matter,
Right?
and we are opening a new one. Mr. Hart's against the library again.
Nope.
No, really.
No, this is-
we're
this is
tagging
the-
it with the
We're
other
clo-
existing files.
we're just opening a file
For the task force.
for this subcommittee.
Yes.
All right,
Setting
and
it
you
to-
want a number assigned, and it's going to be.
I mean, if it needs a number assigned, that's fine.
Particular issue. Not
Yes.
Yes.
Of
Yeah.
Not the,
nonprofits
not,
not providing information.
yeah, or the degree to which they
must
Like-
must comply with the
this,
Sunshine
yeah.
Ordinance.
Would you like us to restate it? So Barker, okay, so we'd like our DCA to look at this Hart's case, the Barker case we heard earlier, and the Smith case with reference to the Sunshine Ordinance containing any provisions applying to third-party entities that provide funding to city bodies, and in particular, nonprofit entities.
That's perfect.
Yeah,
Yeah, that's perfect.
because we're coming across a lot of these unclear situations, and the intent is to, after his comments, bump it back to the full task force for for discussion and possible action.
Right, and some of the confusion seems to arise from a lot of these partnerships have come up with their own agreements that aren't consistent with each other, so
Right.
confusion arises.
That make sense? Yep. Okay. Just to kind of keep the ball moving forward, because we're going to be tearing our hair out on this for many different cases.
Okay, thank you, everyone. I think we're ready to move on to the next item.
Item number 6, file number 19017, hearing on the status of the order of determination. Complaint filed by Alika Vafi, Asian Americans Advancing Justice, Asian Law Caucus, Jeffrey Wang, Council on American Islamic Relations, San Francisco Bay Area, Alan Schlosser, Northern California American Civil Liberties Union, against Lieutenant Catherine Whalen and the Police Department for violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner.
Do we have representatives from the petitioner here? And do we have someone representing the respondent? Okay, great. So let's hear from the petitioner first. And give us a second to get the clock ready, and then please identify yourself. Thank you.
Good morning. Good evening. My name is Javeria Jamil, and I am an attorney with the Asian Law Caucus. Thank you for holding this hearing to follow up on the task force's order from July 16th. I'd like to take this time to update the committee on FFPD's non-compliance with the task force's order, the status of the litigation on this matter, and new information disclosed by FFPD in the litigation. I would also like to ask that the committee recommend to the full task force that it include SFPD's refusal to disclose the white paper at the FBI's request in violation of the Sunshine Ordinance in its annual report to the Board of Supervisors. So as a reminder, there is high public interest in the disclosure of the white paper we are seeking. The white paper is a document about San Francisco law and policy that has a real impact on the Arab, Middle Eastern, Muslim, and South Asian communities of San Francisco. We are seeking this white paper against the backdrop of the FBI actively lobbying the city to rejoin the Joint Terrorism Task Force, or JTTF, and at a time when the issue of San Francisco's participation in the JTTF has been addressed in a public report by the civil grand jury and will be discussed at an October 3rd public hearing of the Government Audit and Oversight Committee of the Board of Supervisors. So on July 16, the Sunshine Ordinance Task Force found that SFPD violated the Sunshine Ordinance and ordered SFPD to produce the white paper with appropriate redactions. SFPD informed the task force that it would not disclose the white paper at the last hearing. We also had a case pending against SFPD in Superior Court when the task force hearing took place, and SFPD had refused to disclose to the task force and to us the subject matter of the white paper as of the last hearing. So as of today, SFPD has not complied with the task force's order and has not released the white paper to us. I also want to bring attention to new information that SFPD disclosed relevant to this issue during the litigation. So during the court case, SFPD communicated for the first time in their opposition papers that they believe Federal Law 28 USC Section 534 prohibits disclosure of the white paper. SFPD never conveyed this alleged basis for withholding in their written responses to us as required by the Sunshine Ordinance. Neither did SFPD identify federal law as a basis for withholding in prior proceedings before the task force. SFPD also confirmed the subject matter of the white paper. In a declaration submitted by Chief Scott, SFPD confirmed that the white paper is the FBI's analysis of local law and policies related to SFPD's participation in the JTTF and Department General Order 810. As you may know, Department General Order 810 is public. So is the Memorandum of Understanding that SFPD had previously signed with the FBI when it participated in the JTTF. The only specific example SFPD provided of what the white paper includes in terms of content is the police department's staffing levels, including the number of officers devoted to counterterrorism efforts. However, SFPD has disclosed this type of information publicly under the Save San Francisco Civil Rights Ordinance in the past. No other examples of confidential information were described. SFPD also disclosed the header of the white paper, indicating the FBI only purported to loan the white paper to SFPD and limited its dissemination to internal use. The FBI, during this time, also rescinded its loan of the white paper to SFPD. However, it did so only after the task force ordered SFPD to disclose the white paper, after we filed the lawsuit, and on the eve of the city's opposition papers being filed in the case. Finally, SFPD informed the court that they would not return the white paper to the FBI until after litigation has concluded in this matter. Our writ petition is currently pending before the Court of Appeal to challenge the Superior Court's ruling that federal law prohibits disclosure of the white paper. However, we have not received any assurances from SFPD that they will not return the white paper to the FBI until litigation has completely ended. So we have two requests of this committee. First, we ask that this committee confirm with SFPD that the white paper is still in fact in its possession and has not been returned. Second, despite our best efforts and the task force's decision in our favor, SFPD has flagrantly refused to comply with local law and respect the Sunshine Ordinance process. They refuse to cite the actual reasons they think the white paper cannot be released. They also refuse to comply with the task force's order. So in other words, this process has not really worked. So we therefore ask the committee to include information about this case, particularly SFPD's refusal to disclose the white paper, and follow the Sunshine Ordinance process in the task force's annual report to the Board of Supervisors. Thank you. Do you have questions?
Thank you.
We may have questions after.
Yes, we're going to hear from the respondent first. Thank you.
Good afternoon, Commissioners. I'm Lieutenant Andy Cox of the San Francisco Police Department. I am currently the officer in charge of the SFPD Legal Division. I replaced Lieutenant Walland. So if I may, to respond first, I wanted to bring up a possible error in the order of determination. That was dated September 20th, 2019. I'd like to point to page 2. It's the second to last paragraph, the last line. It says that Lieutenant Walland stated that once litigation is concluded, the police department will provide the requested document. If you check the audio file of this, I believe it was the commissioner to your right, Ms. Lude, that actually asked her, sans a court order, is SFPD going to provide this? And he said, is that a fair question? And she said, yes, that's a fair question.
Thank you.
Okay. This just kind of made it read like we were going to give it up. Okay. What I'd like to present to the commission is I have copies of the order denying petitioner's motion for preemptory writ of mandate.
Are we receiving this for the first time?
I believe so, yes. This is the denial of the initial writ that the ACLU described, or I'm sorry, the caucus described. This is what's currently in appeal. As we were at the last commission, the July 16th, they were discussing their motion for the writ to have it turned over. This is actually the decision from the court.
And did you send this to our administrator?
I don't know if it went through the DCA or not to your administrator.
Basically, is it in our packet?
Yeah.
I'm not aware. It might have been sent through the city attorney's office.
Or should it even be in our packet? Do we need to see this?
I don't know.
I don't know.
Can you describe it again? What is the document?
Sure. It's I could even read it to you. It's the order denying petitioner's motion for preemptory writ of mandate from the Superior Court. No, I have copies for the entire panel. Yeah.
Wait, Joe, we don't know if we.
I don't think this really affects us. This is something that's going on outside of our purview. So, no.
Okay.
No, thank you.
So this is in response to, at the last hearing, the petitioners had asked, saying that they had a court order going, that they had a writ to have the court demand that SFPD release the white paper. This is an order denying that motion.
That's fine, but we're operating under the charter, which is different.
That's
Okay.
That can go on in parallel. It can die. It can go in a tandem. That's all right. But we still need to do our job based on what we have on the ordinance.
Would you like me to describe what the order entails, or what it?
Well, just go ahead and finish your presentation, and we'll have some questions afterwards.
At this time, we are not releasing it.
Okay, that's pretty clear. Anything else to add?
No, just since it appears you may not have already received this, I will confirm that you do get a copy of it.
Okay, thank you.
Thank you.
Right. Again, I'm having trouble finding the original OD.
Yeah, I'm not seeing it in here either.
Submitted late because I didn't get it from Bruce.
Okay.
Okay. Is it, and it won't be in our minutes either, right?
Pardon me?
It's not in our minutes. It's not in another way we can track it down. Okay. I'm just struggling because I wasn't here for this, so perhaps my other members can fill me in as to, based on the petitioner's presentation, which was very thorough and complete, it seems like, they've jumped through all the hoops as far as the ordinance is concerned. We ruled in their favor. And
We did rule in their favor.
And nothing has been produced. That's kind of where we're at.
Actually, could we have the petitioner come back up again? I had a question. You said that you had received something, like the heading, or you received some part of the document? No.
So we have not received anything. What I was describing was, like respondent mentioned, there was a parallel court case going on, and during that court case, SFPD disclosed information verbally and
about the document.
About the document. Nobody has seen the document yet.
Okay.
And this body determined that even though this document wasn't produced by the police department because they received it, it became a public document and therefore disclosable. Was that our position?
Yeah, and I'm a little bit confused about this loaning of documents and then saying they're not on loan anymore. I mean, it's not a library book. But thank you. Actually, could we hear from the respondent again? Thank you.
Thank you. I know
My question is about
it's
loaning of
so
documents.
that's actually, and as the other commissioner said, he didn't want to hear about, that's actually what's brought up in this, is the court actually supported the federal government's ability to have a document that is considered on loan to an agency to be able to be taken back. So it's no longer in our constructive, we no longer have constructive possession of the document.
What exactly does that mean?
Yeah, that's.
Do you have the document or not?
I can't comment whether we have the document.
That sounds like a yes to me. Thank you.
Would you like any other answers?
Nope. That's good enough.
Thank you.
Thank you.
So it seems that we made a determination, and we made an order of determination. We requested that the document be produced redacted. We understand that there might be sensitive information in it, but
That hasn't happened.
that has not happened.
Okay. I think we need to have that document submitted correctly into the package. That document, we're not going to accept it now because it was late. But if that, and again, I'd like to hear from our DCA if, we have our own purview, what's under the ordinance in the city of San Francisco, and we've ruled a certain way. Does a federal judge trump that or not? I can't answer that, but I think the DCA would be able to opine on that. We have had cases similar to this, so I would make a motion to continue this, accept that document into the discussion, have our DCA comment on it, and also get this back to the full task force where we have some legal minds that can kind of grapple this a little bit because. Short of just setting it up for, willful violation, I think we need a little more analysis from a legal perspective.
I think that sounds like a good idea.
Yeah.
Yeah.
Second.
Okay, so are you making a motion?
Yep.
Yeah, I think that was a motion, yeah.
Okay, and we have a second?
Yep.
Okay, let's take a vote. Oh, no, public comment. Any public comment from parties not involved? Seeing no public comment, let's take a vote.
Okay.
Member Highland?
Aye.
Member Highland, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion passes.
Thank you, everyone.
And maybe we should get this, on the next possible full task force.
I think that's a great idea, if that would
Because
be
there's some
possible.
timeliness issue, obviously attached to this.
Yes.
So, all right. That would be technically next week, wouldn't it?
Oh, my goodness.
That gonna happen?
Yes, that would be next week.
I guess
I'm getting
Chair
happy.
Wolf will. We can discuss that with Chair Wolf when he's here later this evening. But that might be something to remind him about. I'm not sure how close the agenda is to being finalized.
I haven't uploaded anything, and I won't until Friday, so if we have anything
Okay.
to add, this is the time to do
Yeah.
it.
So someone
Okay.
just maybe if
Thanks,
you could
Cheryl.
have a conversation with him this evening and say this one, because for obvious reasons, for timeliness reasons, I think this should probably get to the top of the list. Well,
Do you want to call a whole hearing for this matter again, have both parties show up, or just you want a discussion on?
I think we should just have discussion. I'd like to have discussion with Bruce Wolf when he's here after rules, just to tell him where we got to in this, and if we
And then
can.
maybe have it heard in November? Because the October agenda's been set. I just haven't.
That's what
published it.
that's what I was asking you. Yeah. Okay.
Yeah,
but we technically
Chair
still
Wolf
have time.
has set the agenda. There have
Okay.
been some people who've
Okay, we'll talk
withdrawn
to.
their complaints.
I see.
But
Okay,
I will upload the agenda on Friday.
We'll talk later.
We'll talk
Okay.
after.
Okay.
So getting back to the
Sorry.
agenda, I think Cheryl, you had previously said that number 7 were,
Mr. Dolan.
Yes, Peter Dolan informed me that he was unable to attend today's hearing, and I
Right.
informed the respondent of same. So,
so let's move on to the next item.
Do we want to maybe continue that?
Yeah. I'll make a
excuse me,
motion to continue.
item number 7.
Yeah, this is the first time that
this is
Peter
the first
Dolan.
time that this particular matter was to be heard.
Okay.
Yeah.
So if you could, I mean, we can make a motion to continue it, but if you could also get in touch with Mr. Dolan and ask if he would like that
That's a good idea.
We're granting him a one-time
Reprieve.
continuance. Yeah.
Well, this is the first time he's asked for a continuance, so that's something that I can tell him he can have.
Okay.
That doesn't mean.
That's fine.
from the
Okay,
committee.
great.
Okay. So
If there's a subsequent continuance request, then I would bring it before the committee. You would make a decision.
all right, I'll make a motion to continue this item to the call of the chair.
Second.
Let's continue it.
Can we take that by acclamation?
Can we take that by acclamation?
I think we can.
Okay, great. Thank you. And let's have item number 8.
Just to go back a second, there is a member of the public in the room. If you'd like to comment on that motion, I see a head shaking.
We're seeing no.
Okay, just for the record. All right.
Caller, are you available?
Yes, I am here. Can you hear me?
Yes.
Oh,
This caller is anonymous and is appearing by telephone because I believe he's out of state.
No, I'm in California. I just want to be anonymous. So yeah.
That's fine. That's fine. Let me read the item. Item number 8, file number 19089, complaint filed by Anonymous against Dennis Herrera Bradley Rusi in the Office of the City Attorney for allegedly violating Administrative Code Section 6721D by failing to respond to a public records request in a timely and or complete manner.
okay. So we have the complainant on the phone, and do we have the respondent or someone representing the respondent here? Okay. Thank you. So we'll hear from the petitioner first.
You have 5 minutes. Up to 5
Good
minutes.
evening, Chair and members of the committee. I am the anonymous complainant in case 19089 versus the Office of the City Attorney. This case is about whether the City Attorney is properly fulfilling its mandatory duties as a supervisor of records under 67.21D. Now, the City Attorney has told you that you have no right to tell the supervisor of records how to do their job, but you have jurisdiction under 67.30 to conclude whether any person, including the supervisor of records, is violating the Sunshine Ordinance. Now, in this case, the agenda is slightly wrong. It is 67.21D, but it's a failure to provide a determination for a petition, not a failure to provide a response to a public records request. On May 8th, I made an IDR to the Office of the Mayor for certain calendar records, and the Mayor provided what I felt was an incomplete response. Now, your full task force will, next Tuesday, in case 19047, determine who is right in that case. But the merits of 19047 are not before you today. On May 15th, I filed a 67.21D petition to the Supervisor of Records, and 4 times for the next 3 months, Mr. Russi told me that they would have a determination, quote, next week or soon, as you can see in page 621 of your packet. However, not until a different committee of your task force on August 20th found that the records were indeed public, and I filed this second complaint, did I get a response 103 days later on August 26th where they denied my petition. Now I'm going to read to you the second sentence of 67.21D. Quote, the supervisor of records shall inform the petitioner as soon as possible and within 10 days of its determination whether the record requested or any part of the record requested is public. The city attorney would like you to interpret shall and within 10 days as just a mere guideline. But if you do that, you gut the entire Sunshine Ordinance. We would have no way of holding public agencies, including the city attorney, responsible for their violations. They're also going to stand and argue that my petition was so complex and raised such novel concerns that this is just an extraordinary case that they had to respond so late. They're also going to raise possibly the rule of reason in the same vein. But that does not apply to the supervisor of records, as I discussed in my packet on page 640. Now, I'd like you to, if you can, turn to page 636 of your packet. I did an analysis, and in the last 4 years, they issued 15 determinations, all denials, and only 2 of 15 were made within 10 days. Otherwise, on average, these petitions were pending for an average of 33 days with a maximum of 70 days, and of course that does not include my own. But it's not just the deadlines that the supervisor of records is violating. Of course, the case has changed since I initially filed my petition, since the supervisor of records did respond, but they still here failed to perform their duties. They are supposed to determine if any part of the records are public. But as you can see on page 643, I actually had to file 2 subsequent petitions for the same set of records because the city attorney didn't do their job and determine that certain records were public in the first petition. On the deadline of the second petition, on September 6th, which is 10 days after August 26th when I filed the second petition, the mayor and the supervisor of records, somehow within 4 minutes of each other, both turned over additional records and then provided a response to my second petition that neither denied nor granted the petition. And they have no right to do so. They are supposed to provide a determination. There is no mootness provision which says that if after you file the petition somehow magically they give you the record, they no longer have to provide a determination. And if you look at page 638, you will see my analysis of all 51 petitions to the supervisor of records from 2015 to 2018. Out of the 35 they merely closed with no determination, I believe about 20 of those were ones where they should have given a determination because they had jurisdiction and records did exist, but they were just disclosed later on. But they said no determination needed. Of course, all 15 that they did provide a determination for were denials. By failing to provide written determinations, both timely and in writing, when the public is right, but the city is wrong, they are abdicating their responsibilities. And I ask, under your jurisdiction, under 67.30, that you find the city attorney is and has been violating 67.21D. Thank you very much.
Thank you.
Anybody in support of?
Anyone in support of the petitioner?
No one?
Seeing no one, we'd like to hear from the respondent.
Good evening, task force members. John Cote. I'm the communications director for the city attorney's office. I will just point you to our written response in this matter, dated September 5th, 2019. That contains our position, and if you have additional questions, I am happy to answer them.
So just as through the chair, this is a new case. We're determining jurisdiction, and we're kind of packaging it to send up to the full task force, correct?
Yes, that's correct.
Okay. And it's interesting to note that it's tied to a earlier item, so that's of note. So I'll make, I guess, a motion to find jurisdiction. It seems pretty clear-cut that we're within our purview.
So we have a motion.
Well, it's sent to the full task force, you mean?
Right. Yeah.
Find jurisdiction, records of public, send to the full task force.
Yes. Do we have
Second?
a second on this? Okay. Open for discussion. Is there
Public
comment?
on that?
May I comment something? Sorry.
Sure.
I want to make sure that the motion is correct because the agenda is slightly wrong. I'm not asking you to find that records are public. I'm asking you to find a violation of the section.
Yeah,
Hold on one second. We don't find.
We haven't got there yet. So what we do at this subcommittee, just in case you're not familiar, is we first of all make sure it falls within our jurisdiction, and we're just about to take a vote on that. And then the second thing we're going to do is, make sure the case is unpacked. Everything have everything we need from both parties, and then we're going to send it up to the full task force for a proper hearing.
So we have to find jurisdiction as part of. Sorry about that. We have to find jurisdiction as part of our normal process. So that's just kind of our procedural thing. But yeah.
So we have a motion to find jurisdiction. Do we have a second?
Kinsey.
Second.
Okay. Let's take a...
Take the roll?
Yep, thank you.
Okay. Member Highland?
Aye.
Member Highland, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion is sent to the full task force passes.
Okay. As far as the next piece, I want to go back to something the petitioner said about the, I guess, a typo in our description. If you could repeat that on the line. You mentioned there was something.
Certainly.
Yeah.
Certainly.
Make sure we get
Let me
that.
pull up your agenda exactly. Yeah. Okay. So basically on line 3 of page 3 of your agenda, it should say section 67.21b, that part is correct, by failing to provide a determination in response to a petition in a timely and or complete manner. That is what the violation I'm alleging.
Okay. Our package number is slightly different than what you're quoting there. So do you see a page number at the bottom? Would it be 620?
Oh, he's, I believe, saying on the agenda itself. Is that correct?
Okay.
Yes, on the agenda it's wrong, but in my complaint it's correct. Yeah.
Okay. That's the important part, that it's
Yeah.
in the complaint. But just a note to our clerk to...
He's saying that the language on that the wording on the agenda doesn't match what he has placed in his complaint.
I'll check that out.
Yes, to make sure that when it does appear, it's matching. That'd be good. And I see that now. Okay, got it. And then what page does the response start on that you referred us to?
Is it 674 or?
Let's take a look.
Are you, was that a question for me? Sorry, you need to say, because I can't see,
No,
I don't know who you're
I'm
asking.
sorry. No,
Sorry.
this is for the respondent. Sorry. Yeah, so he made a statement saying that basically everything that they're responding to is in their response, which is
Yes, it looks like it begins on 675.
great. And it'd be nice in future if that was indexed also, just to have it. Give us 1 second. We're going to take a quick look at that.
I apologize. Can anyone who is at the podium speak into the mic? Because I can't hear whoever is at the podium. I'm sorry.
Oh, so that wasn't from the podium. That was from Member
Right.
Highland.
So yeah, so we're as a body, we're taking a look at the respondent's response, which is a memo dated September 10th, 2019, which is in page 594 of our package. I'm sorry, 675, correction. You can read along if you like. So just bear with us here a second. What page is it?
Page 675 is what we're looking at. This is in item number 8.
Yeah. Reopen everything.
I'll help you if that's easier.
Got it. Okay. So members, just take a look at this and see if we want to ask any questions of the respondent while we have him. That looks like a 2-page response.
Actually, I do have a question about compliance with the 10 days for the respondent.
And Mr. Cote is taking the podium to answer this question for the anonymous online.
So, hi, thank you. So looking at this, and there's mention here that this office has never viewed the 10 days as an absolute deadline. Do you mean that as an absolute deadline for providing the information or for responding to a request?
For providing a determination.
Okay. So what do you typically do within 10 days?
Respond to the petitioner.
Thank you.
But surely that's a process of responding. First of all, determine, are the records public? Are they disclosable? And that's part of the process, is it not?
It would be, yeah.
Okay. So I don't understand that 10 days, an absolute deadline. I mean, it's all of the duties of the supervisor of records is within that 10 days. So how could one of them be outside of the 10 days? I don't understand what this letter is referring to. Are you understanding? Are you reading this the same way?
Maybe, Mr. Cote, could you
Sure, I'm not
explain
quite...
further what is the intention of this in terms of saying that that's not a
So in paragraph,
not viewed as an absolute deadline.
So paragraph 3, you write, Sunshine Ordinance contemplates the supervisor records will respond to petition within 10 days. Admin Code 6720. However, this office, which is Sunshine Code Ordinance and Trust, has never viewed the 10 days as an absolute deadline.
That's correct. So we receive requests at various times that involve complex and unusual matters. This would be one of them. And in those situations, it's not practical or even possible to give a thorough and full analysis of the issue within 10 days. And so in those instances, as we did here, we respond to the petitioner and acknowledge receipt of their petition, but at the same time haven't made a determination about it yet.
So I believe I understand what you're saying. What you're saying is that you respond to requests for information by saying, we've received your request. Either it's clear and easy and you respond immediately, or you say, we need more time because...
Yes, for the most part, but I want to be very clear. This is not a request for information. This is a request for a decision. They're asking the supervisor of records to make a determination about an issue. It's not a situation where they're just simply asking for records to be turned over. I mean, ultimately, that is what they're seeking from the original department or entity that they submitted the Sunshine request to, but that's not necessarily what they're asking the supervisor of records to do. Does that make sense?
Yes, and
Okay.
actually, so I'm curious about this no determination and these instances of no determination. Can you talk about that a little bit more?
I'm not prepared to talk about that this evening. I mean, that's not the issue that is before the task force in this particular complaint, number 19089. That's not what they're alleging. They're alleging that we have to respond within 10 days with a determination, and our position is that we do not.
Mm-hmm. And the original request was for the mayor's calendar? Was it as blanket, as general as that?
The underlying request that led to this petition was about the mayor's calendar, correct?
Okay, and specifically in 19089, what are they asking for?
They're trying to say that our office, the office of the city attorney's, the city attorney's office, didn't give them a determination in our role as the supervisor of records about their complaint about that request to the mayor's office.
Okay, I think
it's a bit attenuated.
Yeah, I think I got it.
Can I respond to that?
Sure.
So the issue, the reason that that even the response that they gave after the 103 days wasn't complete is because the mayor hadn't actually indicated they had withheld certain records. So that first petition never even, their response didn't even consider that. These are the so-called non-property calendar records. And so only the second response even considered those records that had been withheld. I apologize. It's hard for me to respond because I can barely hear what Mr. Cote is saying, so I'm trying to guess based on what you asked him what happened. So.
Okay. No, that helps a little bit.
But if you would like clarification of something, please do repeat what Mr. Cote said because I can't hear it. I apologize.
Is it a volume issue, clerk? Maybe.
It's all the way up.
Yeah. Okay.
It might be
I think
something
we're-
about the microphone on
I think we're
the
just
podium.
not close.
Yeah.
I
Yeah.
think he's just not close enough.
Yeah.
He's not.
All right. Stand by.
How we just not close enough to the.
Okay. So at this point, where are we with this, members?
I'm still trying to unpack it a little bit. I've just about got it all, though, I think. We've had cases like this before, requests of the mayor's calendar. I think what name comes to mind, but I'm not sure off the top of my head where we were with that.
So just to clarify again, this is about getting a determination that so the records were not provided. The petitioner went to the supervisor of records for a determination and did not receive a determination within 10 days. Okay.
And it looks like a second complaint is what did elicit some information, but the petitioner feels that's incomplete. Does that sound right? Online?
So remember, the time that I actually filed the complaint, they hadn't responded at all. So all I could say is you haven't responded. But now they have responded, and I'm saying they haven't actually issued complete determination. As in, so yeah, there are two issues. One was when I filed the complaint, no determination had been given, and it was long past 10 days. And then when they gave me the response letters, and now they've given me two, it's still not a complete determination. Even when they clearly found that some additional public records were public, they existed, City disclosed them to me, but they didn't say in writing, as I believe they should, yes, we grant your petition in part, and we find that these records are in part public, as they should.
Got it. So we don't usually, we will forward this up to the full task force. We don't usually make a recommendation, but my guess is we probably will find at least a timeliness violation that looks pretty clear. There's other nitty-gritty to sort out as far as how much of the mayor's calendar is disclosable, and we've had other cases on that have drawn the line in the sand, if you like, and I think when this goes before the full task force, we'll be able to bring those precedents up and make a better determination. But I think we have everything we need to forward this to the next level, which is to present it to the full task force. And did you mention that your original case is appearing in an upcoming meeting? Did I hear that correctly?
Yes. So on Tuesday, your task force will actually determine these electronic metadata cases for both emails and the mayor's calendar. So they're both coming this Tuesday.
I think you mean
Wednesday.
next Wednesday. You mean, right? October 2nd.
Sorry, whichever one is October 2nd. I apologize.
Yeah, next Wednesday. Okay. Okay, and that's just dealing with that particular case. But I mean, really, this whole thing should be looked at together, shouldn't it? And that's a question to my fellow members. What's on the agenda, Madam Clerk?
Next Wednesday?
Mm-hmm. Let me take a look. Is it online?
No,
It's not
it's
online.
going to be published on Friday.
Okay. And you've told Anonymous that it's going to be.
Mm-hmm.
Okay. That's where he's getting this information.
I mean, does this
All
need? I mean, it would be elegant if it were all handled at once, but I don't know. In some ways, it seems like it's two separate
Is there a way you
issues.
can bring it up on Wednesday and say we heard this? And I mean, it wouldn't be on the agenda because it's not timely.
Right.
I mean, we could still find a violation on the original request for timeliness, and it would just be no response. But then all this new material will come in, and we'll be discussing a second case. That's an interesting one. Yeah, I think what we need to do at this point, Anonymous, is just to acknowledge that we've got this information, we've got the respondent's letter, send this back to the full task force.
But it might not be heard next week.
It might not be heard next week.
Right.
But the chair, who's actually appearing here later this evening on different matters, may determine that this will be heard together, and you'll be noticed of that, as will be the respondent. But that's not something that we can make a determination on right now at this minute in this subcommittee.
So on that point, so I have presentations for those two cases that I know are coming next week. But if I need to prepare a presentation for 19089 as well next week, because it's due tomorrow, I hope you guys can let both me and the city attorney know.
Well, I tell you what, you just said the magic word there, 2 cases. If you already have 2 cases on the docket, that is currently our limit. So we probably would not be hearing this 3rd case.
Yep, I understand.
It would be elegant to have them all together, especially if they are all of a similar matter, which I don't know because I haven't seen either of them.
Yeah, that's.
But based on what you just said, it sounds like this particular case would not be heard next week. So I'm pretty confident in that.
Okay, so
I could possibly set it for November. I've started an agenda. And then I can talk to Victor tomorrow and see what he thinks too.
okay, so you're suggesting that maybe November for this one.
Maybe November, yeah.
Okay.
Yeah. Did you hear that? So this.
Yeah, no, I completely understand, because this is not actually about the records. It's about the
Right.
supervisor of records role. So they're pretty different,
Right.
actually. Yeah.
Yeah.
Okay.
It's
All right.
yeah.
Okay, so I think at this point we're going to make a motion to recommend this to the full task force for their consideration as a separate, separate item.
Do we have a second for this motion?
Oh, second.
We've already taken a vote.
We've already taken a vote. I think. Never mind.
No, we took a vote.
No, we on jurisdiction. Actually, we do have to take a vote.
Yeah, we did.
No, it was jurisdiction, records are public, and to forward to the task.
No, it wasn't. It was just jurisdiction. We did it separately. Usually we do it. Sometimes we do it together, but I just wanted to get that out of the way first. Yeah. So this is actually a second vote on the records are public, and referring it to full task force. So that's the motion.
Second motion.
And Member
And-
Hinsey seconded that, I believe.
So let's
Take public comment on that.
public comment. Seeing no public, let's call roll.
Member Highland?
Aye.
Member Highland, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to have the records public and refer to the task force passes.
Thank you to both parties. We appreciate your participation.
All right.
Thank you, John.
Thank you.
very much.
Okay. Next item on the agenda.
Adjournment.
Okay. This meeting is adjourned. Thank you.
All right.
Thank you.